I see. Okay. La Universidad de Insurgentes, hay un grupo de alumnos ahí, más allá de otros colegas aquí de la UNAM, profesores, investigadores de la UNAM y de otras instituciones. Les agradezco mucho que nos hayan acompañado hoy. En primer lugar, tengo que transmitirles las disculpas que pide el magistrado Manuel González Oropeza. Él es actualmente, él es colega aquí del Instituto de Investigaciones Jurídicas. Él actualmente es magistrado del Tribunal Electoral del Poder Judicial de la Federación. Tenía mucho interés en estar aquí. Realmente él ha escrito sobre este tema del juicio por jurado en los trabajos que él ha hecho. Existía figuras de juicio por jurado en México en el siglo XIX. Él lo ha estudiado y lo conoce muy bien el tema, por eso lo invitamos a acompañarnos hoy. Él aceptó con muchísimo gusto, nada más que por el puente parece que cambiaron la sesión previa de el Tribunal Electoral. Entonces ahorita él está reunido con los dos magistrados, pues decidiendo asuntos muy importantes, sobre todo en esta coyuntura del proceso electoral. Entonces no pudo permitirse el lujo de venir aquí a acompañarnos, pero él les manda un saludo y las más sinceras disculpas de su parte. Mi nombre es John Ackerman, soy investigador aquí del Instituto de Investigaciones Jurídicas. Estoy muy contento de tener aquí al doctor Hiroshi Fukurai. Él es profesor de la Universidad de California en Santa Cruz, donde un servidor estudió su doctorado. Entonces lo conocemos a Hiroshi muy bien. Él es del Departamento de Sociología. Ha escrito sobre temas relacionados con la justicia desde un enfoque de la sociología del derecho. Tiene varios libros, los voy a traducir solo en inglés, pero traduzco los títulos. Uno es Raza y el jurado, la acción afirmativa y la selección de los jurados. Ese es por el editorial de la Universidad de Nueva York. La anatomía de un caso de abuso sexual a un niño, el niño se llama Mick Martin. Ese es otro libro. Otro se llama el desempoderamiento más bien se llama Jurado y Raza, el desempoderamiento de las razas y la búsqueda de la justicia. Otro se llama El destino común, Japón y los Estados Unidos en la época global. Y en general sus intereses de investigación tienen que ver con sistemas de jurado a nivel internacional, el derecho internacional, la justicia internacional, la desigualdad racial, sociología del derecho, derecho y política en Japón y en Asia del Este, ¿no? Ha trabajado como consultor a jurados en más de 100 casos criminales, juicios criminales a nivel estatal y a nivel federal en los Estados Unidos. También ha publicado más de 40 artículos arbitrados, artículos de investigación, y actualmente forma parte de la mesa editorial, el consejo editorial de la revista de Derecho y Sociedad, Law and Society Review, ¿no? Originalmente Hiroshi fue ingeniero, ¿no?, de ciencias metalúrgicas y materiales, ¿no? Fue su licenciatura original, y ha sido también profesor en otros campus de la Universidad de California, en Riverside y en la Universidad de Texas, antes de trasladarse a la Universidad de California, donde ha estado los profesores más eminentes destacados en la Universidad de California en Santa Cruz en 1990. Lo acompaña dos estudiantes de licenciatura que están trabajando con él en este trabajo internacional comparativo sobre el juicio por jurado. Clark, Robert Knudsen, que está ahí adelante, que pueden platicar con él después. Los dos hablan español. Hiroshi no habla español muy bien, aunque va a hacer su esfuerzo. Y Susana y Irene López, que está aquí con nosotros. Ellos dos son alumnos de licenciatura en sociología, ¿verdad? En sociology, ¿no?
Legal Studies.
Y estudios legales y de derecho. Lo que pasa es que el derecho es un estudio de posgrado en Estados Unidos, hacen estudios preliminares apenas de derecho. Ellos lo vienen acompañando, trabajando aquí. La forma que lo vamos a hacer es que Susana primero nos va a leer un breve abstract de la ponencia en español. Hiroshi, su trabajo es en inglés, lo repartimos en inglés para que puedan seguir, ¿no? El inglés va a hablar en inglés, no tenemos traducción simultánea, lamentablemente. Sí lo estamos grabando el evento, entonces lo pueden comprar el DVD después y verlo y verlo otra vez para fortalecer su inglés. El paper aquí está, lo tienen. Si faltaron copias, pide a su vecino por favor para que puedan revisar ahí mismo les puede ayudar a una compresión. Al final yo haré unos muy breves comentarios y abriríamos para una discusión, debate. Evidentemente es un tema muy polémico, se vale debatir, discrepar. Las preguntas pueden ser en español, nosotros le traducimos con mucho gusto a Hiroshi, y en la parte de preguntas y respuestas con mucho gusto lo hacemos una traducción ahí, ¿no? Entonces, pues sin más, demos la palabra primero a Susana, que nos comparte el resumen rápidamente en español, y a Hiroshi después para que nos imparte la cátedra sobre el tema del juicio por jurado en México, de un enfoque, bueno, más bien el juicio por jurado en este enfoque comparativo de México, Japón. Bueno, ahorita vamos con el resumen para que Susana le explique más a detalle. Gracias.
Buenos días. Este trabajo examina el posible restablecimiento del sistema de jurado y explora su aplicación más amplia en los procesos penales en México. A pesar de una larga historia de los juicios con jurado, el uso práctico de la fase oral y contradictorio ha desaparecido prácticamente en México. Si bien la Constitución mexicana tiene una provisión para un juicio por jurado en casos relacionados con la prensa, artículo 20.7, casi todos los casos penales ahora son juzgados por los jueces no jurados. Recientes iniciativas federales en México han tratado de transformar el proceso de justicia penal y la introducción de un juicio por jurado en las causas penales. Iniciativa Federal de 2001 de reforma del Código de Procedimiento Penal propone la más amplia aplicación de los juicios por jurado en las causas penales. Si bien esta iniciativa no se llevó a cabo, la reforma judicial de 2008 introdujo los principios de un juicio oral, la presunción de inocencia y el proceso penal acusatorio en México. A pesar de que en 2008 las medidas legales no han incorporado un juicio por jurado, no obstante, la introducción de nuevos principios jurídicos pueden ser considerados como otra indicación de México de la intención de incorporar la participación laica en la administración de justicia. Un análisis empírico internacional de opiniones, actitudes y sentimientos sobre la participación laica en los asuntos judiciales se desprende que, en comparación con los ciudadanos de otras naciones, los mexicanos están más dispuestos a participar en el juicio por jurado y expresaron una mayor confianza en y al respeto de la gente capacitados para hacer decisiones justas y equiditas. La gran mayoría de los mexicanos también apoyará la aplicación más amplia de participación laica en la administración de justicia. Dado el fuerte apoyo para el sistema de jurados, los gobiernos federal y estatales deben estudiar el potencial de creación de un sistema de jurado en México. La transformación futura de México del clásico sistema de jurados podría permitir a los ciudadanos mexicanos a participar directamente en los procesos penales y hacer que el proceso penal aún más abierto y transparente. Gracias.
Gracias, Susana. Muchas gracias, Susana. Ahora le damos la palabra, por favor, y un cálido aplauso a Hiroshi Fukurai, por favor.
Thank you very much for the opportunity. Oops, it's not okay. Thank you very much for the opportunity, John, and as well as the faculty and staff I work here at the UNAM for making this presentation possible. I really appreciate your efforts and as well as kindness extended to me so that I can actually talk about my research. As John has already indicated, I'm a professor of sociology and I'm also a professor of legal studies at the University of California, Santa Cruz. And I have been studying the jury system for the past, I would say, 25 years. And for the past 10 years, I have focused my analysis from the U.S., which I have focused for the past 15 years or so, exclusively to the kind of jury systems that are springing up all around the world. And I have looked at all kinds of jury systems in Spain, which has instituted the jury system in the 1990s, and I'm sure that many of you may remember that Russia has instituted a jury trial in 1995. And Japan is going to start in 2 months the jury system from the May of 2009. And South Korea has already started the jury trial the last year. So I was looking at many countries in the world, first in Asia, then Europe, then North, Central, and South America. And if you really study the trend of the jury system and its new established domain in Latin America, Venezuela has instituted the jury system in 1999, right after Hugo Chavez became the president. Bolivia has just passed a constitution that has a provision for jury trial in its new constitution. And Argentina has also, one of the states have started the jury trial a few years ago. So it's a worldwide trend. Now, if you look at the countries around the world, they started the new system of so-called lay participation in making legal decisions. So I'm now focusing on Mexico, and because of 2001, the federal initiative called for the reintroduction of jury system. Even though it was not implemented, from my perspective, I would say, unfortunately, but from other legal scholars, they say, well, probably that was the best, that Mexico should not have a jury system. Nevertheless, I want to talk about why it is important to establish the system in which people from the community will be empowered to make legal decisions in criminal cases. And in many countries, the U.S., Hong Kong, New Zealand, and many others, they also have a civil jury trials. So I'm going to talk about first the social political significance, why jury is so important in our society. And unfortunately, I cannot speak English, not English, Spanish. So I have to present my presentation, my thesis in English. So I'm going to read this, and if you have questions, you can always ask me after the presentation. Okay? Okay. The historic political reason for insisting on lay participation is that it offers an important check on judicial and political power exercised exclusively by the government. The jury's role as popular oversight of the government becomes especially important when a group of citizens have been accused of committing serious crimes against their own government. After 9/11 and the passage of 2001 Patriot Act, that is in the United States, and similar anti-terrorism measures imposed in other nations in the world, serious terrorism charges have been brought against their citizens, political dissenters, and civic activists. In Australia, for example, after the passage of the Anti-Terrorism Act in 2002, 2 separate juries examined charges of terrorism. In Australia's first ever terrorism trial, which took place in 2005, the all-citizen jury acquitted the defendant, who is 25 years old, who also works at a supermarket as an attendant, of terrorist charges of preparing to storm government offices and shoot officers in a supposed suicide mission. In the second highly controversial trial, in which the only government evidence was defendant's confession extracted at a Pakistani military prison, the jury found Joseph Thomas guilty of charges for intentionally receiving funds from Al-Qaeda. However, soon after the verdict, the appeals court reversed all of his convictions because it determined his coerced confession at the foreign prison to be inadmissible. In Russia, after the passage of the Anti-Terrorism Act in 2004, the jury acquitted 3 suspected terrorists of the charges of a gas pipeline explosion in the Republic of Tatarstan in September 2005. 2 of the defendants, who were among 7 Russians released from the Guantanamo Bay prison in 2004, claimed that they were tortured while transferred and detained in Russia. They criticized the government of false charges of extremism without any substantial evidence. Out of the jury trial, acquitted 4 men of terrorist charges for the murder of Minister for the National Policy, in which only evidence used to implicate defendants consisted solely of confessions extracted under torture. In another high-profile terrorist case of December 2004 attack of the headquarters of the Anti-Drug Enforcement Agency in Kabardino, Balkaria, jury also acquitted all defendants of the terrorist charges. In New Zealand, after the passage of the Suppression of Terrorism Act in 2002, the government also brought terrorism charges against their citizens. In one of the most celebrated trials in 2006, the all-citizen jury acquitted a freelance journalist and political activist of seditious conspiracy. The government evidence included political pamphlet in which the defendant called for, quote, for minded New Zealanders to commit their own acts of civil disobedience against governmental oppression, unquote. The jurors did not accept the governmental arguments and returned the verdict of not guilty. In the United States, all citizen juries also have tried suspected terrorists. In December 2005, a Florida jury acquitted former University of South Florida professor Sam Alarian. I'm sure that some of you may have heard his name. He was a tenured professor of computer science. And he was charged of providing political and economic support to terrorists and conspiracy to commit murder abroad, money laundering, and obstruction of justice. In the highly celebrated trial, the government produced over 100 witnesses and 400 transcripts of phone conversations obtained through 10 years of investigation. In the post-verdict interviews, one of the jury members expressed that, quote, there was absolutely no evidence of any wrongdoing on the part of Alarian, that is the name of the professor, unquote. Similar views were also expressed by the defense counsel that concluded that the prosecutor's case was so weak that there was no need to call defense evidence in the trial. In February 2007, a grocer and university professor were also acquitted by the Chicago jury of a terrorist conspiracy to finance Palestinian political organization of Hamas. In October 2007, another jury acquitted 5 defendants of nearly 200 combined terrorist charges in Dallas, Texas. 5 defendants were former officials of the Islamic charity and philanthropic organization that provided financial assistance to the poor in the occupied Palestinian territories. Many nations in South and Central America have also adopted more contemporary versions of representative all-citizen jury. And Mexico's attempt to reinstate the system of all-citizen juries and introduce a more transparent and adversarial criminal procedure may help improve the perception of the overall efficiency of the administration of justice and increase the level of confidence that Mexican citizens had in their own legal system. The increased confidence in the judicial system in Mexico is also important in the eyes of international communities because a weak judicial system has been subject to fairly significant criticisms of corruption in the past. Mexico, for instance, ranks 65 out of 158 countries in Transparency International's Corruption Perceptions Index of 2005. Now I want to talk about the jury trials that really took place in Mexico. Past research indicates that Mexico exclusively used jury trials between 1856 and 1929. Historical records show that prior to 1856, juries were also used in various provinces and cities. Mexican juries have played an important political role in the criminal justice system and deliberated on many prominent criminal cases, including the trial of Jose de Leon Toral, who murdered President-elect Alvaro Obregón, as well as a trial of Maria Teresa de Landa, the 1928 Miss Mexico, who allegedly killed her husband. However, after the end of the Mexican Revolution and the creation of the National Revolutionary Party, also known as PRI, in 1929, the jury trials began to gradually disappear. Today, a jury trial is rarely used in Mexico, and judges are currently empowered to determine legal outcomes of nearly all criminal cases. Now, let me talk about the jury trials in the 19th century Mexico. Article 185 of the Constitution of 1825 first authorized the use of jury trial in Mexico. The jury was responsible for determining whether or not there was a legal foundation for the accusation and was given the task of evaluating or assessing the nature of crimes or disputes. The jurors were then named by each city council. The jury court in Querétaro, Mexico, I can pronounce in Spanish, Mexico, okay. Querétaro, Mexico, for example, dealt with both civil and criminal cases. Ministers and prosecutors of the Supreme Tribunal of Justice established the jury. The jury generally consisted of 12 citizens chosen at random by the city parliament. The early record of Querétaro shows that on March 4, 1826, the city parliament first created a list of potential candidates to be summoned for jury service. To be qualified to be a jury member, the potential candidates must be at least 35 years old and not member of clergy or his employee. The city parliament created a new list of jury candidates in 1827 and again, 1829. The list of jury candidates was prepared periodically so that a new group of eligible residents could serve on the jury trials. The following example of criminal case illustrates how the jury trial was held in the 19th century Mexico. In Querétaro, on July 4, 1862, two men, Jose Pereira and Francisco Salina, were charged with the crime of stealing cattle. The jury was then summoned to decide this matter, and judicial panel of 9 citizens consisting of 8 men and 1 woman was chosen at random from the list. Once their names were randomly chosen, they were summoned. They were legally required to show up the following day for the trial. The record also indicates that if they failed to summon and respond to jury summons, they would be punished and fined for their failure to appear in court. The federal judge and legal scholar Manuel Gonzalez Oropeza, who is also a professor here at UNAM, argues that one of the most controversial amendments to the Mexican Constitution has been the right to jury trial. The Mexican Constitution originally provided each state be responsible for including a provision for individual rights in their respective jurisdictions. According to Oropeza, Jose Maria Luis Mora, an attorney in the state of Texcoco, was a strong advocate for the institution of juries and wrote powerful essays in defense of jury trials in Mexico. He also helped to draft jury rules that were later approved under Article 209 of the Mexican Constitution, which stated, quote, "No tribunal of the state can pronounce a sentence in criminal matters for severe crimes without a grand jury and without certification of a petit jury to determine the motivation of the accusation. The Spanish Constitution of Cadiz of 1812 has also influenced jury trials in Mexico, especially in crimes involving press offenses. According to Oropeza, those remain two major legal guarantees in Mexico that allowed jury trials to become the indispensable adjudicative system between 1828 and 1883. Jose Maria Luis Mora believed legal knowledge was an unnecessary component of people's ability to serve as jurors. Nevertheless, Mora was not successful in moving his jury project forward. When the congressional hearing was convened in 1856, Ignacio Vallarta, a strong opponent of the use of jury, insisted that the jury should be left for other nations that are more cultured and civically mature, so not in Mexico. In November 27, 1856, Mexican Congress finally voted against the implementation of jury trials, 42-40. In June 15, 1868, President Benito Juarez brought back the jury in criminal matters for the Federal District Court. The jury was then guaranteed by CPP of 1880, the Law on Criminal Juries in 1891, the CPP in 1864, and 94, the Law on Judicial Organization in the Federal Districts and Territories in 1903, and organic laws of the Ordinary Court in 1919 and 1928. However, on October 4, 1929, Code of Organization, Jurisdiction, Procedure in Criminal Matters to the District and the Federal Territories finally abolished the intervention of the popular jury in the judgment of general criminal cases. Today, Mexico only authorizes the jury at the federal level to intervene in criminal proceedings for the press-related crimes against the public order or internal or external security of the nation. Despite a long history of jury trials prior to the end of Mexican Revolution in 1929, practical use of popular jury in open and adversarial court has all disappeared. However, 2008 reform laid an important foundation for the possible establishment of the popular jury system with the legal principles of the use of oral arguments in proceedings, adversarial system that presumed innocence until proven guilty, and placing the burden of proof on prosecutors. Several states have already proposed and introduced oral and more transparent criminal proceedings in Mexico. In 2004, the state of Nuevo León introduced the oral adversarial criminal procedure in non-serious culpable offenses. The government of Nuevo León also won approval of an access to information law that included not only the executive branch, but also legislative and judicial branches. Similarly, Zacatecas and Chihuahua introduced their own reforming initiatives to introduce open and transparent criminal procedures. Chihuahua courts also introduced the plea bargains, mediation, suspended sentences, probations, and other legal tools to effectively process their criminal cases. And those legal changes have a dramatic effect on the efficacy of the criminal cases. Of more than 1,000 cases filed in the city of Chihuahua in 2008, only 8 went all the way to an open trial, and in Ciudad Juárez, 6 of more than 1,000 criminal cases were tried in an open and adversarial court. In May 16, 2006, International Forum on the Relevance and Feasibility of Establishing Mexico's Popular Jury was held in Sucreños for the forum in Mexico City. And many scholars, civil employees, citizens of diverse countries shared experience on the challenges and potentialities of the restoration of Mexico's jury system and held debates on the road to improve the system of justice. The international discussion on the re-establishment of the jury system in Mexico was extremely timely and symbolic, especially given the fact that many Central and South American nations have already introduced and democratize their criminal justice system, including Nicaragua, Guyana, Belize, Panama, Brazil, Venezuela, Bolivia, and many Caribbean countries. Now I'm going to talk about the 5 other countries which I examined, the college students and university researchers' views and their attitudes about lay participation in making legal decisions. So I will give you a brief synopsis of the lay justice system in those 5 other countries to which I'm making comparisons, the results I obtained in Mexico. So let me talk about the lay justice system of 5 nations, of which citizens were asked to respond to a set of questions on the popular jury, and opinions were empirically analyzed in this paper. Those countries include United States, Ireland, New Zealand, Japan, and South Korea. The U.S., Ireland, New Zealand, and South Korea have adopted all citizen jury system in which people are selected at random from local communities to make decisions in criminal cases. The tradition of jury trial in Ireland, U.S., and New Zealand came from British tradition through their colonial history, and Britain has transplanted both grand and petty criminal juries and civil jury trials in those countries. Japan once had a criminal jury trial between 1928 and 1943. But the jury trial in Japan was suspended by the Japanese military government in 1943 because of only men 30 years and over with property were allowed to serve, and more eligible jurors could afford to serve at the end of the war. Nearly 6 decades after World War II, in May 2004, the Japanese Diet passed a Lay Assessor Act and set up 2 different panels for the criminal trials. A panel of 3 professional and 6 lay judges is asked to make decisions in a contested criminal case, whereas a panel of 1 professional and 3 lay judges is used in an uncontested case where the facts and issues identified by pretrial procedure are undisputed. In 2007, South Korean Parliament also approved a judicial reform and set up their jury system in criminal cases. While the decisions are not binding, the judges use jury verdict as an important guideline for determining final trial outcome. South Korea's legal transformation has been quite remarkable because, unlike Japan, South Korea has never had a history of jury. The introduction of the popular jury also impacted another branch of the South Korean government. 2005, Ministry of Defense announced that it would adopt a jury system in which officers, non-commissioned officers, and rank-and-file soldiers could participate as jurors in an effort to increase public trust in military tribunals. Prior to the introduction of lay participation, South Korea also revived its election law in 2005 and granted the right to vote in local elections to permanent foreign residents living in Korea for 3 years or more, including ethnic Japanese, Chinese, Mexicans, Latinos, including Mexicans, and other minority groups. The 2005 law also lowered the voting age from 20 to 19, thereby expanding the voting population. The changes in the electoral system and expanded political franchise are seen as a sign of South Korea's movement towards the development of a fairer and more balanced democracy in East Asia. In all those nations, jurors are selected at random from local legislative roles. There is no specific requirement as to gender, race, ethnicity, or educational background to be eligible to serve. Thus, in theory, every citizen in those countries is treated equally and considered as an able, trusted element of society and capable of making fair and just decisions in criminal trials, thereby contributing to judicial governance of the society in which they live. Whether or not Mexico will be ready to follow the footsteps of those nations is the question examined in the following empirical analysis. Now, many of you may have the table, so I'm going to talk about first Table 1, then followed by table 2. So if you look at the tables, I think you can actually get deeper understanding of the analysis I'm providing. Now, empirical results tables show analysis of views and attitudes and opinion of college students and university researchers. Between 2005 and 2008, 2,000 respondents from 9 private, state, and or national colleges and universities in 6 different nations were contacted and asked to provide their views and opinions on the popular jury. And those 6 nations examined include Mexico, Japan, the US, Ireland, South Korea, and New Zealand. Now, if you look at table 1, the overwhelming majority of Mexican respondents felt confident they could make a fair and just decision of jurors, like 74.3%, and that they are most likely to base their decisions solely on facts and evidence presented in court. That was like a 73%. The later figure shows the highest confidence level among 6 nation respondents. And those and other results show that Mexican respondents tend to hold their greater faith and respect for the popular jury and people's abilities to engage in deliberation and determine a fair and equitable verdict based on factual evidence and information. Mexico's high confidence in low participation shows stark contrast to the confidence expressed by Japanese respondents, in which only 27% of Japanese respondents felt confident in making a fair and just decision. It's startling, despite the fact that they're going to have a jury trial in 2 months. While Japan's late justice system begins in May 2009, many scholars and citizens have expressed their concerns about the effect of low confidence on the overall quality of the deliberation and trial outcomes in Japan. Despite the fact that Mexicans today do not have the opportunity to participate in jury trials in general criminal cases, empirical results suggest that Mexicans are more willing to accept the jury system as an important form of adjudication, and they certainly express their willingness to participate in the trial process. Now, let me talk about table 2. That measures the confidence of various respondents on the government, the court, police, jury, and so on. Now, this table 2 shows people's confidence in the government. Mexican respondents' confidence in the police was the lowest among 6 nation respondents. Only 16% of Mexican respondents said they are confident in their police, a large percentage point below to any figures of other countries. Not only did it show the lowest confidence in all 6 countries by a large margin, but it also showed the lowest confidence on the prosecution. That was only 27%. Mexico, in fact, is the only nation among 6 countries where respondents' confidence in prosecutors, the police, and the court failed to reach the majority. The majority of Mexican respondents, however, showed confidence in juries, 54%, and also confidence in defense attorneys. More than half of Mexican respondents have shown the confidence in defense attorneys. In other words, if you look at defense attorneys and jurors, people's confidence about those 2 entities, their confidence in those 2 entities are much higher than the court, prosecutors, and or police. But if you compare those figures with other countries, Japan showed the lowest level of confidence in juries. It's simply the opposite. Only 44% felt they are confident in the jury, followed by South Korea, 45%. So among the countries with a long inquisitorial judicial justice system and civil law tradition, such as Japan and South Korea, Mexico clearly shows the highest level of confidence in jury. Now let me talk about Mexico's history, as well as I believe Mexico has been one of the leaders in North America in terms of democracy, and how the jury system will contribute the furtherance of the democratic effort in Mexico. The past research shows that progressive history and tradition of Mexico's social and political efforts to advance the democratic ideals of equality and direct participation of politics and law. Indeed, Mexico may have been one of the most important leaders of democracy in North America for the last 2 centuries. The U.S. media proudly boasts that newly elected Barack Obama became the first African president to lead the nation in the Western Hemisphere. Of course, this is not true. As nearly 200 years ago, it was Mexico as the first nation in North America to choose the African president, Vicente Guerrero, a son of former African slaves. President Guerrero became the second president of Mexico on April 1st, 1829. While his tenure was cut short by political unrest and his untimely death in 1831, his accomplishment and historical legacy was never forgotten. President Guerrero signed a decree in 1829 that abolished the system of slavery in Mexico. He also helped write Mexico's constitution, took various steps to educate and elevate its poor and people of color. The Mexican state of Guerrero was dedicated to him who fought for the freedom and independence of Mexico. Historical records show that, as illustrated in the jury trial of Querétaro, women often participated in jury trials as jury members in the 19th century. In the United States, however, the political, legal maneuvers and strategies successfully prevented women from serving in the juries. And it was only 1979 when the U.S. Supreme Court finally ruled in Durham versus Missouri that the automatic exemption given to women was declared to be unconstitutional. The jury was also a very important political institution for Mexicans in the American Southwest when the U.S. government claimed its jurisdiction after the Mexican and American War. Mexican juries in the newly occupied territory served as a powerful check on the potentially prejudicial attitudes and behavior of European American prosecutors and judges. In 1846, U.S. declared war against Mexico, occupied Mexico's northern territories, now called the American Southwest. From 1850, New Mexico then became a federal territory and continued its colonial status until 1912, when New Mexico finally became the 47th state. In the territory of New Mexico, Mexican women were not allowed to serve as jurors. However, Mexican women were permitted to testify as witnesses in court. Legal historian Leo Gomez stated that, quote, Mexican women testified quite regularly as general witnesses for either the prosecution or defense and in either grand jury proceedings or trials, unquote. Despite the fact that blacks and other racial minorities were prohibited from testifying against white, Mexican men and women in New Mexico routinely testified against European American defendants. In the politically colonized Southwest, and despite racial subjugation of its Native American populations in the occupied territory, Mexicans exerted significant political and judicial power through their active participation in more than 80% of grand and petty juries. Mexican residents played their role as the key witnesses and jury members in criminal trials. Since the majority of residents in New Mexico were Mexicans, the centrality of Spanish language in trial proceedings created a strong sense of ownership of both legal and cultural space among Mexicans. Majority Mexican juries then functioned as a significant oversight of white judges and other law enforcement officials. In the legal environment where judges, prosecutors, and many law enforcement officials are almost exclusively selected from European American communities, Mexican juries served as a powerful check on the potentially prejudicial attitudes and discriminatory behavior of white prosecutors and judges. Mexicans in New Mexico successfully resisted European American legal and political control and domination through active participation in the popular jury. Powerful social legal strategies of the U.S. government to subjugate Mexicans to the political will of the dominating power have been effectively neutralized by the high degree of legal participation by Mexican residents in jury trials. Okay, let me conclude. Now, the conclusion, let me say the following. We believe Mexico is ready to set up the jury and promote active civic participation in criminal trials. A cross-national empirical analysis of views, attitudes, and sentiments on lay participation shows that compared with citizens in other nations, Mexicans are more willing to participate in jury trials and have expressed greater confidence in and respect for jurors' ability to make a fair and just decision. The great majority of Mexicans also have supported the broader application of lay participation in the administration of justice. Given the strong support for the jury trial, federal and state governments should explore the potential establishment of the jury system in Mexico. By modeling after a popular jury system currently adopted in more than 60 countries around the world, the future transformation of Mexico's classic jury system and criminal procedure may allow Mexican citizens to directly participate in the criminal trials, make the criminal justice proceeding even more open and transparent, and build a strong democratic foundation for the creation of civil society in Mexico. Thank you.
I think I'll make my comments in Spanish, Hiroshi. Is that okay?
That's fine.
To encourage people to participate, perhaps, or maybe I'll do. Yeah, okay. To encourage people to. Voy a hacer nada más unos cuantos comentarios, reacciones. Este trabajo muy sugerente, incluso provocador, ¿no? Que nos hace pensar y reflexionar sobre el sistema de justicia en México. Lo primero que yo señalaría es que ya tenemos un sistema de participación ciudadana en un asunto parecido, sino igual a los jurados y el derecho penal. Y esto es la forma en que hemos diseñado en los últimos 15 años la recolección y conteo de los votos ciudadanos en las elecciones federales y locales. La construcción del IFE va de la mano justo con la construcción de un sistema de, si bien no es un jurado, es una mesa directiva de casilla en que por ensaculación invitamos a los ciudadanos, una pluralidad de ciudadanos, para participar en la vigilancia y el conteo de los votos en las elecciones. Estamos confiando a un ciudadano, a un grupo de ciudadanos comunes, mexicanos. No hay una selección elitista en absoluto, es un sorteo totalmente por el primer nombre de la letra del apellido, por el mes de nacimiento. Es ahí donde se empezó a construir realmente esta confianza en el Instituto Federal Electoral en esas elecciones. Veníamos de una historia de gran corrupción, gran autoritarismo, de elecciones injustas, sesgadas, y la solución que se inventó en la reforma, bueno, ya es desde 94 incluso, pero ya más consolidado en 96, es a partir de la ciudadanización del Instituto Federal Electoral. Había desde ese momento, y todavía hay críticas, pensando que quizás no es la mejor forma para integrar mesas directivas de casilla. Por ejemplo, en la elección de 2006 se hizo crisis un poco este modelo. No sabemos si la gran cantidad de errores aritméticos en las actas fue por un problema de capacitación de los ciudadanos, un problema de educación, conocimiento de los mesas directivas, o una cuestión de infiltración de intereses externas, politizadas, pero se hizo crisis porque una de las razones por lo cual sigue habiendo ciertas dudas sobre 2006 es esta gran cantidad de errores que existen en las actas. Quizás sería un error echarle la culpa a esta participación ciudadana, pero sí habría que señalar este momento como un momento en que nos ha obligado a repensar esto. Pero yo entraría por ahí, porque los casos históricos son también muy relevantes, lo que menciona el doctor Fukurai, y nos recuerda que en México sí teníamos este sistema de juicio por jurado. También yo creo que vale la pena rescatar toda esta experiencia de los juicios por jurado de los mexicanos en los Estados Unidos después de la conquista del territorio mexicano, que ahora es territorio estadounidense, en que el doctor Fukurai nos está invitando a recordar, nos está informando que en esos espacios integrados, geográficos integrados donde vivían los mexicanos, podían utilizar este mecanismo para defenderse un poco de la imposición de un Estado de Derecho racista, ¿no?, por encima de los intereses de esas poblaciones mexicanas que vivían dentro de los Estados Unidos. Ahora, por lo menos es interesante muy interesantes estas cifras que nos presenta Hiroshi. Me pregunto, por ejemplo, si los japoneses son más honestos o realmente son más sesgados en su punto de vista. O sea, aquí you're saying that the Japanese only trust, how many, 27% you're saying? Trust the jury trials, and in Mexico it's what is it, 70? O sea, que en Japón solamente unos 27% de la población dicen que ellos mismos podrían confiar de ellos mismos en como jurados, cuando en México es más del 70%. I wonder whether the Japanese are more honest, or perhaps they're actually they're less objective. I don't know. It's obviously more of a cultural issue, perhaps. I don't know what's happening there, but it's very interesting. Y lo que sí llama la atención es que en México confiaríamos más. Yes, go ahead.
Japanese system is kind of unique because if you go to Japan, and it's very highly advanced, and probably every college student has probably 2 or 3 cell phones. Mm-hmm. It's not very unpopular to have all those multiple cell phones, so it's very technologically very highly advanced society. People are very trustworthy of people and the system. But if you try to understand how the Japanese criminal system works, this is a fact. 99.9% of criminal cases result in conviction. You cannot get higher than that. And 92% of criminal cases result in confession. In other words, once you are being arrested, you will be under extreme psychological and physical condition, coerced to make confession. Mm-hmm. And those confessions become so-called criminal evidence for the conviction. That's why Japanese criminal justice system, we have 99.9% conviction rate. Even in the civil cases, more than 97% of the cases, okay, that involve litigation against the government, judges make decision in favor of the government. So citizens win less than 3% of the civil cases.
30?
No, 3%. More than 97% of the cases, judges make decision in the favor of the government. But you have to remember, the judges represent the judicial bureaucrat of the Japanese government. They are paid and they are employed by the federal government. So when you think about 99% conviction rate in criminal cases, 97% winning ratio of government in civil litigations, do you think it's a fair society or not? No, I don't think so. So that's one of the reasons that many social activists and people that have family members who are wrongly convicted, some people say 20 to 30 or even more percentage of criminal defendants are wrongly convicted because of the coerced confession. Okay, that's the figure given by one of the prominent defense lawyers who have worked in criminal cases for decades. He said about 30% of all criminal cases, in a petty, very crimes to murder, are based on the wrongful conviction. So those families and civil activists and many legal scholars have expressed concerns about the justice system in Japan. And that's one of the reasons that those groups pressured the Japanese government to have debate and discussions about the possible introduction of the jury system. And that's why now the Japanese government reluctantly has accepted the kind of commitment that they established a jury system, which will start in 2 months in Japan.
Pues fascinante lo que nos comenta el Dr. Fukurai. O sea, aquí en México, here in Mexico, the problem is exactly the opposite, right? We have a rampant impunity, right? So, drug-related offenses, which is the big hot topic today, only 5% are convicted of people who have been accused. Only 17% actually are brought before court, and out of those, only a third of them are actually convicted. So only 5% of all proceedings against drug-related offenses actually reach conviction. So here we have exactly the opposite problem, and the question is whether the same solution can be used to address different problems. I don't know. One of the interesting things about the numbers is are these confidence numbers. Yes. The other thing is that Mexico stands out internationally as a country where there's great distrust in the institutions of justice, of police, of public security, and if this could be a way of reconstructing this confidence through participation directly, this could be an attractive solution. Nevertheless, we need to, I think, also address I don't know about this room, Hiroshi trajo una encuesta para ustedes, para que antes que se vayan también contesten. Israel, si quieres repartirlo. Israel va a repartirles una encuesta justamente sobre sus propias opiniones sobre el juicio por jurado, ¿no? Es anónimo, totalmente. Pero él, como esto es una parte de un estudio internacional sobre el tema, sí les pediríamos, ahora que están escuchando y debatiendo, que llenen. Esta es una calificación de 1 a 10 y unos comentarios muy breves, para que él también se pueda ir pues, sabiendo y aprendiendo de ustedes. My impression is that perhaps the general citizen of Mexico might be in favor of this, but at least among the academic, legal, and judicial community, my impression is that there is an aggressive rejection of this idea, right? The accusatorial oral arguments is already too much, right? Of the imperial imposition of the United States system of law onto the Mexican system, which should defend, this is the idea, should defend its autonomy and its way of resolving legal disputes without receiving an imposition from the U.S. system. Now, that's a gut response from lots of people. Whether it actually is correct or not, we'd have to think about it. I think that we should think about, in terms of, I don't know my own personal opinion about it yet. I think it's convincing your paper. It has to do, I think we should acercarnos and look at this issue from at least 4 different perspectives, right? One would be our theory of knowledge, right? Cómo se construye el conocimiento, ¿no? Si es mejor tener muchos puntos de vista, aunque sean informales y no muy cultos necesariamente, o si es mejor tener un experto, un juez que tiene el conocimiento y la verdad. We also have to think about a theory of political power and autonomy. Otra vez más, tenemos que ver si la autonomía, el poder político, bueno, sobre todo la autonomía, si autonomy is best constructed through a diversity of points of view or through a single independent person. En el caso del ICE, esa idea de la autonomía supuestamente se construyó a partir de una diversidad de puntos de vista de la sociedad civil, que así es como se pudiera resistir, ¿no?, un embate de algún poder público o fáctico, que cuando tienes una persona, por muy experta que sea, es más vulnerable a la imposición político y menos autónomo. Pero tenemos que pensar sobre este tema. We also have to think about our theory of legitimacy and confidence. ¿Cómo se construye la legitimidad? ¿No? La legitimidad se construye a partir de, otra vez, una opinión calificada de una persona experta en la materia, o a partir de la transparencia, la participación ciudadana. Y finalmente, we need to think about our theory of democracy. Hiroshi, el doctor Fukurai mencionaba que en un momento dado se buscaba descalificar a los juicios por jurado, diciendo que los ciudadanos no eran suficientemente maduros, que no tenían suficiente conocimiento para tomar esas decisiones. Es una descalificación clásica en contra de la democracia misma, ¿no? Históricamente se ha descalificado a la democracia diciendo que los ciudadanos no tienen suficiente conocimiento siquiera para votar. Y aquí la pregunta, si pueden votar, ¿por qué no pueden también participar en estos juicios penales, ¿no? Depending on how we stand on these different theories of knowledge, of autonomy, political autonomy, of legitimacy, and of democracy, is how we're going to be able to decide on this issue. No creo que sea una solución fácil. Yo creo que Hiroshi cree, quizás, it appears that you think that it would be relatively easy to do this in Mexico, or at least it's easy to propose it, right? And that the preconditions are there, and that's very encouraging. I think that the first step would have to be a serious debate about the issue with those actors and judges and lawyers who are very resistant to any kind of change, no? And particularly are just now assimilating, no, this major new judicial reform, and I think this might sound to them as being too radical, sí, quizás, demasiado radicales, ¿no? Yo tengo que asentarme así unos minutitos aquí en una reunión, pero voy a estar aquí unos minutos. Sí, Susana, te encargo a ti que moderas, ¿no? Para que, vamos, you can talk right now, but then I'm going to ask Susana to take the questions from the audience. ¿Sí? Por favor. Sí, espera.
Okay, I just want to say one thing. The Japanese reform did not happen just for the past couple of years. Japanese government has suspended the jury system in 1943. That was 66 years ago. And since then, the Japanese citizens and activists have pressured the Japanese government. So it's 60 years of hard work. It's not just something that happened immediately. So Mexico has the same way. It has a tremendous historical legacy of its democratic foundation. And I'm sure that the Mexican people will have to work hard to make sure that you have the legal foundation for the jury trial, but nevertheless, I'm sure it's going to be realized in some day, hopefully in the near future, because we have the legal foundations anyway, already instituted. So that's my response to John's comment.
¿Sí? ¿Tiene una pregunta?
The main arguments of the main critics of this jury trial.
Oh.
Because I know that you are talking about
okay.
the person in favor of the jury trial. We don't have enough acknowledgement of this jury trial. I would like to know the opposite argument.
Okay.
The argument against the jury trial.
Well, I would say if you can measure the opposition in the forms of, say, reducing the size of the jury, or reducing the applicable cases for the jury trial, as well as relaxing the unanimity rule. That is like, in the U.S., mostly it's a 12-member jury. So there are groups that pressured the legislature, not only at state levels, but at federal levels, to relax this unanimity rule. so that you don't have to have 12 members voting for, say, guilty. Okay? You can have 10 out of 12, or even 9 out of 12. So if you think those kind of pressures for the legislature to have significant modifications in the proceedings involving the jury trial, I would say prosecutors union. All those associations that represent prosecutors and the police have been pressured the legislature to modify the jury system for decades. So I would say prosecutors have really insisted on the relaxation of the unanimity rule, as well as reduction of the jury size. And all the research has indicated, based on social psychological research, smaller size are more likely to vote for conviction, and relaxing unanimity rule will increase the conviction rate. So those are the kinds of interest groups that really attacked not only the integrity of the jury system, but also try to modify the legal context within which the jury trial operates. Is that the answer to the question? Okay.
¿Sí? Pues le puedo dar un resumen de lo que dijo. Pues la pregunta fue ¿cuáles son los argumentos contra los... Sí. Como usted quiera. Sí, en español yo se lo traduzco, no me importa.
Primero una aclaración, doctor. Vicente Guerrero llegó a la presidencia de México a través de un golpe de Estado en contra del presidente que había sido electo, Manuel Gómez Federal. Es histórico, no tiene nada que ver con
So he's saying that the election of President Guerrero was not really anything that had to do with race. It was more just historical.
What a coup, they say. What a coup, they say. Yeah. Aquí, por ejemplo, el hijo de un expresidente de la Suprema Corte, Fabián Aguinaco, padre de Vicente Aguinaco, argumentaba cuando se dio el caso de la ley televisa, que en contra de la Suprema Corte hubiera puesto, vamos a decir, la resolución en internet, porque decía que no, quienes deben de decidir al respecto son las personas formadas en derecho, las que forman la facultad de derecho de la UNAM, etcétera, y no la gente, porque desde su punto de vista, y es el pueblo, la gente, pues se deja llevar por la pasión, no tiene conocimiento legal, en fin, porque en la cuestión democrática que decía John, muchas veces la pasión lleva a que se vote en pro o en contra de una posición y no necesariamente lleguemos a una verdad legal. Entonces quisiera saber, porque en Estados Unidos yo sé también que la burocracia judicial también se consideran así a otro nivel. Las personas que se refieren a Estados Unidos se consideran gente así, como aquí, que no son gente común y corriente, que son gente extranjera. ¿Cómo se maneja en ese caso? ¿Qué se hace, vamos, porque uno de los principios de cómo lo fue de que creo desde la Magna Carta es de que en un juzgado, en un juicio, o sea, el acusado debe ser juzgado por sus pares, ¿sí? Así lo dice la Constitución legal, y si esa garantía llega hasta la Suprema Corte, por ejemplo, ¿sí? Esa es una pregunta. Lo segundo es, quería preguntarle de un caso famosísimo.
Perdón, déjele traduzco primero la primera parte de su pregunta y luego seguimos a la otra para...
Si es necesario, o sea, lo digo en inglés.
Sí, como sea fácil. ¿Quieren en inglés o...? Sí. Bueno, le voy a traducir la primera parte para que entienda un poco. Son of the member of the Supreme Court from Mexico has suggested that members of the jury should be compiled of university, college students, and doctorates, and have that kind of education first, as opposed to a civic or, regular common people that are probably driven more by passion than by what the law would say.
Okay, that's a very good question. And I've been asked that similar questions, not only in Mexico, but also Japan, and also when I got into debate with the people from China, for example. But if you look at the true function of the jury, true function of the jury is not to make a legal decision. It's to make a decision whether the person being accused of crime actually committed the crime or not. Okay? So jury is not asked to have the legal knowledge applying in the adjudication of the case. But nevertheless, jury is simply trying to determine whether people or a person who is being accused of, say, stealing a car, whether he or she actually did it or not. So the basis upon which jurors must use, are only facts. Facts, whether he or she did it or not. They have no consideration of any legal knowledge or legal foundations that you need to have in making determinations. So jury is a fact finder. It's not legal decision maker. Legal decision makers are the judges. Judges will make a decision on the kinds of law need to be applied in the jury trial. But role of the jury is to become a fact finder. So you don't have to have legal knowledge. You just need common sense knowledge. Your knowledge as a citizen living in everyday life in your communities. And your judgment, sentiment, should be used in making decisions whether a person actually did it or not. So that argument has been raised by many people around the globe. In China, for example, 2004 legal reform has actually created the legal standard in which to become a lay assessor. The Chinese system is a little bit different from the jury system. In other words, group of professional and lay judges make decisions. Professional judges and lay judges means ordinary citizens, together making decisions. In 2004, law promulgated by the Chinese government mandate lay assessors must have a college degree. And based on the surveys in China, only less than 5% of people living in China have a college degree. That means having that law promulgated, that effectively eliminated about 95% of Chinese citizens from serving in the jury. And even though, so it's not very democratic, it's very highly concentrated and interest group. Because if you think of people who have college degree, say in China or in Mexico or anyplace else, they tend to come from a very particular segment of community with high social class, economically well off. And if you look at those people, those individuals will have the same kind of interest because of the social class they belong as those who are judges or the prosecutors. They also tend to come from the higher social class. So by limiting the jury service to those classes of individuals, you are really having the very highly selected and highly opinionated group of decision makers. And they are less likely to reflect the opinions of the majority of the people in a society. And that's one of the reasons that many societies, even in Japan, even though only 27% of the people want to or have confidence in the jury, but nevertheless, there is no restriction with respect to age, nationality, or age, you have to be 20 years and over. You have to be adult, but there is no restriction in terms of education. If you do not have education, you can still serve. If you have a college degree and PhD, you can still serve in the same panel and work together in making final decisions.
En Japón hubo un caso muy famoso, hubo el asesinato de una niña pequeña, al final, y entonces, bueno, el supuesto asesino era lo que le llaman intocable en Japón. Digo, para la gente que no lo sepa, el doctor lo sabe perfectamente, ¿sí? Hay un grupo de japoneses que son discriminados por los demás, o sea, siguen siendo japoneses, pero se dedican a ciertos trabajos como manejar cadáveres, basura y demás, ¿sí? Y por razones religiosas, o sea, no les acepta el resto de la comunidad japonesa. Entonces, una de estas personas fue acusado, ¿sí?, de haber asesinado a una niña, ¿sí? Las evidencias fueron muy débiles y demás, pero bueno, fue todo un escándalo, se le condenó, ¿sí? Y entonces lo que yo quisiera preguntar, me parece que, no recuerdo bien si hubo jurado o no en este caso, pero si no habría el peligro, bueno, esa es la otra parte de la cuestión, de que un jurado, y el alto porcentaje de condenas que comenta el doctor del sistema legal japonés, es porque el sistema legal japonés simplemente defiende una serie de prejuicios contra determinadas personas, concretamente, por ejemplo, en el caso de estos intocables, ¿sí? Y entonces, a pesar de que no había pruebas realmente en contra de esta persona, fue condenado porque la mayoría de los japoneses tendería a pensar que una persona de esa clase pues sería un criminal o el más posible criminal. Y lo digo porque aquí dentro de la encuesta, aquí dice, la pregunta 7, si una esposa asesinara a su esposo que la abusó, otras esposas deberían ser incluidas en el jurado, porque ese es el otro problema, o sea, ¿quiénes se incluyen en ese jurado? O sea, si se condena, si se está en juicio un negro, tiene que haber negros en el jurado, en fin. Lo digo, por ejemplo, en el caso de que hubiera, por ejemplo, un caso aquí terrible, que fue el caso de Shelley Yegon, o sea, un caso donde hubo un bastante racismo, ¿sí? Sí tendría que haber personas chino-mexicanas en ese juicio, por ejemplo.
Okay, gracias. There was a case in Japan where a member of a group of people that are often discriminated against, untouchables, assassinated or was alleged assassination of a young girl. And he was, despite the fact that there was little evidence of the crime, he was condemned. And so his question goes to whether, referring to the question that we had in our questionnaire about should women be included in the jury if a woman was alleged to have assassinated her husband, who is included among jurors, and if there's this risk of discrimination or prejudgments that Japanese have against the untouchables or religious groups or any other groups for that matter.
That's a very good question, and one of the reasons, and especially the activists who actually represent the so-called black community. Black community is the name of untouchables. I'm sure that's what you refer to. And many black communities actually being forced to confess, and many of them, I don't know exactly, because we don't know exactly whether it's a forced confession or not once they're being convicted. But nevertheless, allegedly, there are a large number of wrongful convictions involving racial minorities, especially black community in the south, middle of the south of Japan. And one of the reasons that we actually advocated for the institution of the Japanese judicial system is that the people who actually live in the black areas, those untouchables, they can actually represent themselves as peers in the trial. Do you understand that? Like, for example, in the United States, there is a very active movement to make sure that racial minorities, African Americans and Latinas, should be included in the jury because the large number of criminal defendants actually come from those groups. By having those groups in the jury, their interests will be reflected in the kinds of decisions made by the jury. So there is a checks and a balance because there has been a rumor, or in many cases it's been substantiated, the police misconduct or racial discrimination in investigative manners. And those racial discrimination involving crimes allegedly committed by racial minorities such as African Americans or Latinos, okay? And people who actually face police in their communities, if they actually sit in the jury box, they can actually incorporate their life experiences and how police conduct itself in the investigation. And sometimes police may lie, police may extract confession, or many other discriminatory investigative techniques being used. But if you live in those neighborhoods, if you see those conducts by police day in, day out, then if you are selected as a member of the jury, then you can actually use your life experience in evaluating the evidence being presented by the prosecutor. Okay? So in other words, any signs of misconduct by police can be construed as not credible. That elevates the standard of the so-called reasonable doubt. And that means it really increases the probability for not guilty verdict. And that's very important because, in other words, if you actually do engage in discriminatory investigative techniques, and if you have, from the police perspective, if the people who live in those neighborhoods where you actually engage frequently in those misconduct, and they see you every day, then they may say that, well, those evidence being presented by the prosecutors may not be credible. So I will vote, or I will even persuade others to vote for not guilty verdict. That's why jury representation from the same tiers of the groups of the likely defendants is very important. And I will give you for the last, the very famous jury structure called the jury de mediatate lingua. Jury de mediatate lingua. That's the jury structure being devised in 12th century England, in which there was a tremendous animosity and discrimination against Jews in Britain in 12th and 13th century. So, King Richard has allowed the Jewish defendants to ask for the split jury. In other words, if you're a Jewish member of the community, if you're being accused, and if you're involved in dispute in criminal or civil cases, you can ask for the jury de mediatate lingua, in which 6 members of the jury will come from Jewish community, and the other 6 members will come from non-Jewish community. That way, the sentiments of Jewish residents being discriminated be reflected upon the deliberation and in the final verdict. So that's very famous, the jury structure being used in England. And the jury researchers have found in the United States in the 18th and 19th century, involving mostly in Native Americans, when they are being accused of crimes, then Native Americans in northeast states or regions have actually called for the jury de mediatate lingua, in which 6 members will come from Native American community and other 6 members from colonies. And so representation is also important. Not only you have to have a jury, but you have to have a group representation.
¿Alguna otra pregunta? ¿Sí?
Gracias. No sé si el doctor sepa si México es una nación pluricultural. En consecuencia de esto, podría suceder el caso que un natural de la Sierra Norte de Puebla o en algún lugar donde las comunidades juzgan a sus integrantes por ellas mismas, que eso es un juicio por jurados como lo menciona, ya se aplica en esas comunidades. Ahora, esas personas son parte de México y el sistema que utilizamos nosotros como una sociedad avanzada, por así decirlo, excluyente de ellos, ¿cómo se aplicaría un método uniforme para que se incluyan a estas personas dentro de los jurados en sociedades como la nuestra, que es muy dividida? ¿Y cómo afectaría la idiosincrasia del mexicano ante factores subculturales como son los emos, los darks, etcétera, 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 que en cierta forma la sociedad los excluye? Esa sería mi pregunta. ¿Cómo podría encontrar una respuesta el doctor?
Okay.
Gracias.
Gracias.
So he says in some parts of the northern Mexico that are not included have already, like you would say, could describe a trial by jury. So his question would be that how would you try to provide a uniform method of, I guess, providing or getting jurors to be included that are from kind of segregated and have different ideals or
That's a good question. And as I said, with respect to the requirement of education, like for example, in the United States or Japan or South Korea or many other countries, as far as I know, there is no geographical restrictions imposed on jury service. In the state of California, in large county like Riverside or San Bernardino, where you have the cities on the western side, like Riverside or San Bernardino, and eastern side, it's at the border of the Nevada or some other states. So you have like tens of miles of distance. And since you have only one superior court, especially in the case of San Bernardino, as far as I know, people who live far in the western side of the county, they can actually ask for the exemption to serve, because they have to actually drive many hours from their residence if they're being summoned to the courthouse. And so sometimes they can actually ask to be excused from serving in the jury. So that's the only restriction that I can see in terms of how geography imposes on the jury service. But in Japan or any place else that I know of, there's no restriction. As long as you are in the domains called jurisdiction, and if you live in the jurisdiction, then residents in the jurisdiction is being selected at random from the registrar's roll. Like in the United States, we use roll of registration. And so jurors are randomly selected from those we call jury wheels. In Japan, there is no registration. And in fact, I'm sure Mexico, you don't have to register to vote. And U.S. is probably the only country that really uses registration. That really hampers their ability to vote. Maybe that's the purpose of the registration law has been functioning in the state. Nevertheless, same in Mexico, same in Japan, same in South Korea, same in any place else. Once you are residents of defined boundary of jurisdiction, then you are eligible to serve. So there is no geographical limitations. Did I answer that question?
¿Sí contestó la pregunta o?
Bueno, mi pregunta no iba encaminada a lo geográfico, sino a lo idiosincrático. Creo que usted lo enfocó al planteársela a lo geográfico, o la entendió mal él.
He wants to know more about the idiosyncratic part as opposed to the geographic part. He doesn't know if you would know, but he's just inquiring.
I don't know much about idiosyncrasy, any sentiments of political or social or even racial sentiments to use the geography as a methods of selecting jurors. But you have to understand the 2001 federal initiative in Mexico has proposed the installment of the jury system. But the jurors have to have law degree. Okay, that's UNAM, Iniciativa Federal. There was an educational restriction. As I said, in no other countries that one I examined, Japan, South Korea, China has one now. But U.S., there is no educational restriction, nor geographical restriction, because the very basic idea of jury service is a democratic participation. Because I will give you this another example. I don't know how many of you have studied Athens, democracy. Athens, the Greek city. Okay, it's called Athenian democracy. I'm sure that you have studied in your high school or college politics or world history. Athens, their government and their all governance was based on direct democracy. In other words, see, in Japan, in the US, and many other countries in the world, they actually use random selection to select jurors, right? Graduals. Random selection, okay? In Athens, government officials are selected at random. Okay? Assembly, that's 6,000 people, as well as Council of 500, and also dicasteria. Dicasteria means it's like a jury. All those three basic institutions, like as we have the judiciary, executive, and legislative branches. And if you really impose that idea into the Athenian democracy, everything was based on random selection, as long as you're a citizen, except you have to be male, unfortunately. But nevertheless, if you're a citizen of Athens, you are eligible to serve as a member of the government for 1 year. You are also eligible to serve as a member of the jury. It's called the dicasteria. So it doesn't have any restrictions about geography. It doesn't have any education. It doesn't have any restrictions about where you live. It has restrictions about gender. It has restrictions about the social status. The slaves couldn't be selected as a member of the government or the jury. So idea of the jury as a random selection, okay? Jury is only institution that survived through Athenian democracy. We do not have a government which is based on the random selection. Okay. We used to have those governments. Now, fortunately, and that's not a direct democracy, because every citizen is considered as able and trusted element of society. And you are able to contribute to the judicial and political governance of the society in which you live. So, as far as the idiosyncrasy of the geography is concerned, if you really go back to the direct democracy, there is no restriction about geography. It's all based on, it's only based on the gender and social status.
ありがとうございます。
どういたしまして。
Sí.
Yes. Okay. That's the first question.
Yeah, that's my first question.
Okay. Every society has so-called the jury eligibility. For example, if you are felon, that means if you have been convicted of felony, and you are not eligible to serve. In the United States, it depends on the states. Some states actually allow the former felons, after they actually served out their sentences, apply for the civil rights. Because once you become felon, again, depends on jurisdictions and depends on states, you lose your civil rights. But after you served out your sentences, then you can reapply for the civil rights. Once you gain the civil rights, then you can actually not only vote, but also you can serve. So there is an eligibility set, and the felony conviction is one of them. Or if you have, in the state of California, if you have a dependent in the family, and if you cannot find any other people to care for your dependents, like if you have a sick mother or father, and there is no other people to care for them, then you can actually ask for the excuse. And so that's another excuse you can use, so that you may not be able to, because you cannot serve on the jury. So there's a set of rules on eligibility, and to make sure that, you know, jury service will not create all kinds of problems for you.
Okay. And the other question is that the jury is prepared in any way to participate in the judgment?
Very good. In the U.S., usually they make decision as a fact finder, whether a person committed the crime or did not. One of the exceptions is the decision that jury has on death penalty. And there are 37 states. Illinois has no longer has a death penalty. But nevertheless, there are 37 states in the United States. The jury have the power to determine whether a person be sentenced to death or be sentenced to life in prison without the possibility of parole. So they have, once you are being convicted of, say, first degree, and the jury has a two choice, death penalty or life imprisonment without the possibility of parole. That means you will stay in prison for the rest of your life until you die. So that's the decision jury has. In the case of Japan, it's very interesting because the Japanese jurors are asked to make a decision along with the professional judges. So they have the professional judges as well as Japanese citizens making a decision whether a person is guilty or not guilty. Also, they can actually make a decision on the appropriate sentence with the guidance of legal information provided by the judge in the judicial panel. So that's the difference.
Okay, so they work together, the judge and the jury.
Yes.
Okay, thank you.
You're welcome.
¿Otra pregunta? Okay, va a ser la última.
¿Es posible usar este tipo de procedimientos para los juicios civiles? En este caso, adopciones, cosas familiares.
Is it possible to have jury participation in civil trials as opposed to just criminal, like adoption and family law?
That's very good. Not in the U.S., not in New Zealand, not in Hong Kong. Those are still the places. Even in Britain, Scotland had a jury trial, civil jury trials. New Zealand had a civil jury trials. Hong Kong, the former British colony, still has a civil jury trial. Canada has some limited jury trials, but not in the tort-related jury trials. Tort means involving injuries, like an auto accident or you got injured while you're working, so you sue employees or drivers of other automobiles. But those civil cases actually are being eliminated in Canada and Britain and many other countries. But in the U.S., we still have the civil jury trials. As I said, same in New Zealand and same is in Hong Kong. In Japan, it's all criminal. South Korea, it's all criminal. And as far as I know, Ireland, I believe it's all criminal. And Venezuela, in 1990, Venezuelan government introduced both jury trial and the lay assessor. 1999, both systems. The jury system is only citizens make decision. They also introduced a lay assessor system. In other words, both like a Japanese system. Judges and citizens make decisions together. In 2001, actually, they abolished the jury system, so they only have the lay assistant system. But as far as I know, they are all applicable only in criminal cases, no civil. So application is possible. Like I said, in 19th century in Mexico, the jury trials were held on both civil and criminal. So there is a possibility, if you really go back, the history of jury trials in Mexico, you have the history of the both civil and the criminal. But overwhelming majority of the countries in the world, they no longer have civil jury trials, mostly on the criminal cases.
Okay, gracias.